it depends on your jurisprudential school of thought, but
there is no jurisprudence where a lawyer can help a client or give a client advice on how to break a law, right? In the United States, right?
I don't disagree with you on that. I'm not taking a position on Eastman's actions as an attorney. But let's just zero it in on Rosa Parks. Let's assume that Rosa Parks read a bunch of laws and is not an attorney and came up with the idea to do what she did.
Sure.
Right. And so, yes, Rosa Parks broke a law, but, and this might not be the best example.
Because it's going to screw all my points entirely because you pointed out Russia.
No.
Okay.
My name's Zachary Worrell. I'm a relatively new attorney. I run my own practice here. I do election law and real estate stuff, but academically, my passion's always been constitutional law and legal history.
Okay.
And before this, sorry, I'm a little out of breath from running up and down the stairs.
No, you're good.
But, before law school, I was a political consultant, largely in Virginia. And my claim to fame in that world was unseating the House Majority Leader Eric Cantor in 2014 in that large upset where he spent $12 million and we spent $200,000. So I feel like I have relevant legal training and some political chops as well to, have a substantive discussion on the matter.
Okay. And then just, I'm live streaming all that, right?
Yep.
Cool.
We're good.
Okay. Okay. So I think apparently you heard my 14th Amendment takes. You were not happy and you wanted to chop shop, I guess, about the Supreme Court decision there.
Yeah. So what initially I had umbrage with was your statement that the Supreme Court had thrown out the 14th Amendment, specifically Section 3, in the Trump v. Anderson case.
Yeah.
I would say, I don't want to put words in your mouth. I only occasionally view your content, but I believe that's wrong-headed because the Supreme Court didn't make it a dead letter. The Supreme Court stated that there are adjudicatory methods that the Congress should pass if they want to do it. And there are also common law methods to deal with disqualified or unqualified individuals taking office, specifically a writ quo warranto. And so I believe that the Supreme Court was correct in stating that a state court was incompetent to adjudicate the federal concern there, specifically for the office of the president. And so my position is that the case was correctly decided. I wish they would have explained a little more clearly that a writ quo warranto would be the proper method to do that. Now, some might say there's no federal common law, and therefore the common law method of a writ quo warranto doesn't apply, but a writ of mandamus isn't specified in the Constitution either. And Marbury versus Madison, in part, was deciding that the federal courts had the authority to issue, that common law remedy. So, I'm curious whether you believe that whether you support those words that the Supreme Court threw out the 14th Amendment.
Yeah. So when you say, for instance, like a writ is required to enforce any of this, what part of the amendment are you reading to get that idea? Right.
So what I would say is, and I don't have the text in front of me, but I know it almost verbatim.
Sure.
So it says that somebody is disqualified if engage in insurrection, et cetera, give comfort to those who support it, et cetera. And so, like almost every other provision of the Constitution, that pronouncement of law does not by itself and cannot by itself substantively produce an effect.
Wait. What law or what are we talking about there?
I'm sorry, I'm talking about the 14th Amendment.
Yeah, but you said something about law, like implying that the Section 3 is talking about like the like adjudication of whether or not somebody committed a crime or something like that.
Sure. So in order for the constitutional bar to apply, there has to be some judicial method of testing whether someone has done the acts that preclude them from holding office.
Is there any other qualification listed in the Constitution or any other amendments that requires that adjudication process?
Well, you could point to Well, I'm sorry. Ask that again. I'm sorry.
Like, do we have to go to court to prove somebody's age, or that like that's a required thing that has to happen in order to, or can a state just say you're not qualified? Like, doesn't every state have a right to figure out what their procedure is for whether or not somebody ought to be on a ballot or not?
So I don't disagree with, I think what's going to happen is you're going to find that I hold a different view on this. I believe that the age and natural born status and all that would require a writ quo warranto or some other method to determine whether that fact that would disqualify them is true.
But traditionally it hasn't, though, right? You can be kicked off a ballot by, like, I don't think you go to court to say that, like, if I were to try to run as a 10-year-old, I think the state just wouldn't put me on the ballot by whether it's their secretary of state, whoever's in charge of their things, right? Like, and if there was a process there, it would be up to the state to do their procedure. Like you just mentioned adjudication. That's what Colorado did, right?
So I actually, for example, I think Cenk Uygur shouldn't have been kicked off the ballot by the states. I think there should have been some sort of adjudication to determine whether he was qualified. That might put me in a minority position here.
Sure.
But
while that's true, though, but very careful, adjudication by whom?
I believe it has to be a federal court of competent jurisdiction. I don't think that the state courts are competent to qualify or disqualify a federal office holder on those on a constitutional level.
That would be why, though? Because isn't a state basically allowed to do like the whole process belongs to the state unless a particular statute has been passed by Congress saying otherwise, right?
Right. So you're talking about the time, manner, place of the election, right? And so time, manner, and place, I believe that I'd ask you where in that language you find that they have any power to determine qualification of the candidate per se, other than, quite frankly, I'm in the minority here. I was going to challenge some of New York's laws on this because I don't think that some of these, I don't think the states have the power to disqualify candidates like this. However, the time and the manner of the election is a question that's wholly distinct from whether someone can assume the office. And
sure,
so
but other constitutional qualifications, none of these other constitutional qualifications ever are adjudicated on some federal level. All of them are just relying on the state processes to figure out if somebody is qualified or not, according to language in the Constitution, right?
Not according to language in the Constitution. My understanding is, and I wish I had a little bit more time to brush up. You responded very quickly, and I get good for now. Mm-hmm. So my understanding is that there is one case on point about maybe it was age or something like that. But generally speaking, the practice has been to allow the states to do this. However, a practice, no matter how long it's been going on or anything like that, doesn't necessarily mean that it is definitively constitutional law. And so, there's an argument on that too. But the point is that this is the first time that the Supreme Court has had the chance to answer questions related to disqualification pursuant to this or any other clause. I could be mistaken, but I've researched this quite a bit over the summer. After the Civil War, like I think that there were federal congressional offices that states enforcing Section 3 didn't allow people to run for that particular office. Like I don't think that, but they had the 1870 the act that was the enforcement legislation for that provision. I think
wasn't that an act that act? I thought that was as per Section 5. I thought that was remedying the injury that allowed those people to run. No, I think that in the 14th Amendment, Section 5, or no, I'm sorry. Actually, I think it was actually Section 3 itself might have said that in order to remedy this injury, the Congress can pass something to allow somebody to run for office or whatever.
Yes. So I think and I don't have the text in front of me, so forgive me, but I'm pretty sure that Section 5 says that and Congress shall have the power, I think that, and those are the first few amendments that actually had that language in it.
Sure. But that Section 5 argument that I think Roberts uses is a dog shit argument because we didn't need Section 5 to enforce Section 1, right? Every single part of the Constitution is, in effect, law. We don't need an act from Congress unless it specifically says it's not law without an act from Congress to enforce it. And I believe that Brown v. Board was overturned because of the 14th Amendment, because of Section 1, and there was no law that needed to be passed to bring Section 1 into effect on a federal level for the Supreme Court to make that decision.
I'm sorry. I tend to talk fast too. Do you mind saying that a little bit slow? Because there are a few parts I want to unpack.
Sorry, when you bring up the requirement of a law part, that's the challenge to Section 3, that it's not self-executing. And then there was this weird fiction created that parts of the Constitution aren't self. Wait, what did I just say? It's not self-actuating,
executing.
Yeah, that for some reason they aren't self-executing. But I mean, if the Constitution says this thing shall be, then it is. It's the Constitution. And Section 1 of the 14th Amendment, right, didn't require a law from Congress in order to have like Brown v. Board of Education come out. So why would we assume that Section 3 would require a law from Congress? Yeah.
Yeah, so I don't believe that's the case. I think that we already have a long established common law method to deal with this unqualified candidates from assuming their office, and that's the writ quo warranto. And so the way that works is a district court, federal district court, I think seated in D.C., has the power to issue a writ quo warranto upon sufficient evidence to remove somebody from an office that they have assumed that they are not qualified for.
I just don't know why we don't need that for any other qualification listed out in the, and you've got the time, manner, place. Yeah. So I don't know why we would assume it to be the case here.
So how do we determine whether whether somebody has engaged in insurrections and is disqualified, therefore pursuant to that amendment? What is your method of determining that?
So that's a challenging question. And if the Supreme Court justices were breathing, constitutional, progressive, crazy people that the conservatives always claim that the lefties and the progressives are, then maybe that would be a good reason to throw out this decision. And that was part of it. I believe they said a patchwork of regulation or a patchwork of enforcement is what would make this bad. But the reality is how you would determine that. It would be determined at the state level, the same way that they enforce every single other qualification. Now, would it be challenging or difficult? Maybe, but then is that the conservative originalist argument that if a part of the Constitution is difficult to enforce, that we throw it out? Or
no, I think that we're having a semantic incongruence here. And so the qualification for office, I believe, is very different than somebody qualifying to be on the ballot for that office.
Okay. Is this a distinction that's made, though?
Well, we're getting outside of the decision, and we're getting more into like legal and constitutional theory here.
Well, sure, but this is where we should be. But I'm saying that, like, is there any state that would allow you to run? Like, I'm sorry, I would have to go back and check. Like, if I were to look up the age thing, the citizenship thing, and the naturalized citizen, or I'm sorry, and then the you can't be president for more than 2 terms. Do these specifically say they shall not be listed on a primary ballot?
Well, okay, so this is the big problem here.
Okay.
When we vote for president, there is no actual vote for that person to take office. There's a mediating body there. And so in theory, the way that it's supposed to work is you're voting for electors, and you're not even I'm against having bound electors and electors distributed according to that's
whatever. Fine, but also to be clear, that's not in theory. That is what's happening, right? And keep in mind that the same people that were arguing about this Supreme Court case and that the federal Congress should have jurisdiction over these matters was also arguing for the independent state legislature theory, which makes these state legislatures even more powerful than they actually are, who are in charge of like picking the electors that you're voting for voting for president. So I mean, like the time, manner, and place clause, I mean, it seems plainly obvious to me, and it seems to be in the historical precedent of the U.S. that all of these restrictions on who can be on the ballot are enforced by the states, and we would expect them to do that, yeah?
So I see what you're saying. I think there are a couple differences here. So let's pull this apart.
Sure.
So, for example, we have in Virginia, to be on the ballot in Congress in a primary, you have to get 750 or 1,000 signatures to qualify for the ballot. And so that's ballot access. Yep. But on the other hand, you have...
Which, to be clear, just to be clear on that, That's requiring access to the ballot for 1,000 signatures for a federal office that is not authorized by congressional statute nor the Constitution. So that's precedence for a state determining how a person goes on a ballot, right? Yep.
Right. I agree with you that functionally is how it is. I do not think that you can add, this is personal opinion, and I don't know how well fleshed out it is legally in the case law, but personally, I think that there's a problem with that constitutionally because it places a qualification, and I don't like using the word qualification because qualifying for the ballot and being a qualified office holder are two different things, but they kind of get melded together procedurally because of the way we do it.
Yep.
So in terms of excluding Trump from the ballot, I do not believe that a state can determine that they have a 14th Amendment disqualification. Now, whether they choose to put him on the ballot, 1,000 votes, whatever, that's a different battle. The main question is, who has the capacity to determine, let's put aside getting on the ballot entirely.
Okay.
Right? Because it muddies the question. In terms of, in terms of somebody being qualified or disqualified, like flipping a switch, how is that person assuming that office to be adjudicated? Forget all of the previous steps in the Electoral College.
In whatever manner the state sees fit.
No. Forget the ballot part entirely. So is person A qualified to assume the office of president? And that's the only question on the table. Yay or nay? How is that determination made?
I mean, right now it could be made during, it could be made on January 6th when people are deciding whether or not they want to contest, I guess, the certification of a particular vote. I guess it could be made on January 20th. The Congress could impeach if they decide that this person is not a valid office holder.
They couldn't. That's not a high crime or misdemeanor, but you're thinking through it.
I don't think that high crimes and misdemeanors are clearly defined in any part of the Constitution. So I don't know if lying in a deposition about oral sex with Monica Lewinsky is a high crime or misdemeanor as well. I don't know but yeah. So I mean, like there are parts of the procedure where maybe the Congress could step in. However, again, while this is an interesting conversation, and I think there's a lot to be talked about here, fundamentally it doesn't matter, right? Like the Congress, like there could be a constitutional amendment that says, in order for the president to be elected, he shall be able to bench press 100 pounds, right? And maybe there's a huge debate over, or like 135, and there's a huge debate over like, do you count one plate or two plates when you're adding up the weight? And that might be a general contention, who knows? But what's in the Constitution is in it, and as long as the text is plain and the text is clear, which it is here, then the enforcement mechanisms and procedures is a separate question entirely. Like if the argument is like, it's difficult to enforce this, we need to figure out how, that's fine. But it's never, especially the job of the Supreme Court, to say it's difficult to enforce this because it's a patchwork, therefore let's throw it out, right? You would agree that would be a bad. That is what they said. No, of course it is what they said. Yeah.
What did they say? They said that this is not the method to do it. I think they advised Congress to pass legislation to enforce it, but they didn't throw it out. That is still a constitutional.
It says, I mean, this isn't the in the opinion. The result could well be that a single candidate would be declared ineligible in some states, but not others, based on the same conduct and perhaps even the same factual record. The patchwork that would likely result from state enforcement would sever the direct link that the framers found so critical between the national government and the people of the United States as a whole. That's not an argument. It's basically just saying like it'd be sloppy, so we're going to just toss it out. That's an insane thing to say, in my opinion, when the text is clear. Now, if the text is unclear, then you move on to things like historical precedent, or how has it been seen traditionally, or what was the intention at the time. There's three things I forgot. I'm sure you remember better than I do. But like when the text is clear and unambiguous, then the text is clear and unambiguous.
Right. So, but see, there's a problem here. And that is what is the mechanism to determine I guess the main question is, did person A engage in insurrection? Did they engage in insurrection? And so the ballot-based patchwork, that question
that you have is, you understand though, this is a question of procedure, not a question of constitutional law, right? There's a separate question.
Correct. Yeah. No. This is not a substantive. Well,
but if this is a procedural question, then you've already granted me the entire constitutional argument. Now it's just a question of procedure. Perhaps states should pass laws for it. Perhaps the Congress can pass laws for it to streamline the process. But we're past the constitutional amendment now. We can't just say that because it'd be difficult procedurally, we'd throw out the amendment, which is what happened, right?
But no, that's not. I strongly disagree with you. They did not say that the 14th Amendment is null, void, and of no force or effect or anything like that. They said that this state cannot disqualify unilaterally on constitutional grounds this person.
Which is in contradiction to every other disqualification part of the Constitution, though.
And again, this is so I think that there's more to be pulled, threads to be pulled here.
Sure, you can think that, but like precedent-wise, there's nothing that can be your opinion, but there's no precedence in the United States for requiring federal government intervention to be listed on a ballot. It's just not the case, right?
I'm not going
to. You can go forward to like the language of the 22nd Amendment is exactly the same, right? No person shall be elected to the office of president more than twice, right? So can they be listed on the ballots for presidency? I agree. There's like a little bit of procedural maybe confusion there. Like, can you be listed on a ballot but not qualify for president? But like historically, we've never thought that like, well, maybe somebody could be listed on the ballot and it's the federal Congress that has to remove them from the ballot. That's just not the case. We don't need an enforcement mechanism. Like all language in the Constitution is self-executing unless we're led to believe otherwise. Like there's just no legal argument against this other than it feels bad.
Yeah. But has that been tested yet at the Supreme Court level, at a constitutional level? I think this is the first time that such question has been answered by the federal court. So just because the federal courts haven't adjudicated it before doesn't mean that this first blush adjudication is invalid or incorrect just because it stands in opposition to practice and history.
Yeah, I never said it was incorrect, though, because it stands in opposition to practice history. I said it was incorrect because it is contrary to the clear and unambiguous text given to us by the Section 3 of the Constitution.
If Section 3 said that no person who has engaged in insurrection, etc., shall appear on a ballot for this office or for federal office or whatever, I would agree with you wholeheartedly.
Wait, but that's not our disagreement. Our disagreement isn't whether they can appear on the ballot. The disagreement that was listed in the Supreme Court case was whether or not a state can keep somebody from the ballot based on this, what they call a federal exception, right?
Okay. Right. And so, again, I think that we're getting into muddy territory on...
Wait. You say muddy territory. None of this is muddy. None of this is muddy at all, to be clear, right? We can say that there's a disagreement versus like, are you on a ballot versus can you be elected? That can be a thing, but that's not related at all to this. Where a disagreement is not whether you can be listed on a ballot or not. It's can the state enforce Section 3 of the 14th Amendment? The Supreme Court has said no, and that seems to be unique to every single provision that would prevent somebody from appearing on a ballot or being elected to office, even when the language is identical, like it is in the 22nd Amendment.
All right. So again, I am standing in opposition to a long-standing history of the way that these have been adjudicated, such as age, for example. However, I would say that if you narrow it down to the most important, the most acute substantive issue, the question is this person qualified to assume and hold that office?
Yeah.
Which is a slightly different question than, is this person allowed to go through the process to then assume that office?
Sure.
Right. And so we're dealing with this lower level thing here, but the Constitution doesn't speak to qualification for a ballot. It speaks to holding the office itself.
Yeah, but wait, do you believe this?
What do you mean?
What you just said, do you think that that's how it ought to be interpreted? My next question is going to be, do you think then that a state can list anybody that they want on the ballot because the enforcement shouldn't happen until the Congress goes to certify the candidate? So if I want to list people that are underage, under the age of 35, if I want to list people that are were president twice before, if I want to list people who are non-citizens, should states have the ability to do that? Because you're saying that it can't even be enforced because it only speaks to whether the person can hold office, not to whether they could be on a ballot?
I personally do.
And do you think, but now the important question is, do you think the Supreme Court, who said that this would create a patchwork of enforcement, would they agree with that?
Would they agree with that? I don't know. To be honest, this has not been brought to them. And I do think that if they start to pull at the thread of this and examine the relationship between constitutional qualifications to hold office versus appearing on the office, we might have a different result, because the way that our electoral system has evolved in the past 220 some years, we've developed a bunch of procedures that might not square neatly with the language of the Constitution.
I don't feel like that's true. I think everything squares away pretty easily. What do you think what do you think is unsolved for by?
So there can be no qualification on holding office other than those that are constitutionally listed.
Is that
right?
Wait, is that true?
Yes.
On holding office, but not on appearing on a ballot for holding office, or
right? No, so there you cannot add to the qualifications or subtract from the qualifications for holding office different than those that appear in the Constitution. So, for example, it would be illegal for a state to say you have to have red hair and a beard to be a qualified candidate for Congress. That's unconstitutional. And so I actually would extend that same logic to say that requiring signatures or whatever other things that each individual state might impose, that's a problem there. But that's a separate question from, is that person qualified to hold the office under a federal and constitutional analysis?
Doesn't this violate, though, the states being allowed to determine how they hold their election?
How they hold the election, not who is. The states are making a preemptive determination on age and that sort of thing pursuant to the Constitution, but they're also making a secondary qualification on holding that office, i.e., you have to get 1,200 signatures from somebody to be elected to that office. And so I think there is a problem there. Now, it's never been tested in the courts. It's certainly never been tested at the Supreme Court level, but you cannot add qualifications beyond those that are in the Constitution for that office. The Congress can't pass a law saying you have to weigh 235 pounds or bench press 135. They can't add those qualifications. So I do think there is.
Is there a way? What is it? What part are we referencing here when we say like a state can't add qualifications or whatever? Or I mean, it's just a predicate of constitutional law. You cannot add qualifications on holding a constitutionally created office beyond those that exist in the Constitution. Okay, I'm not sure. I don't know how that would play out, because like if a state wanted to, a state could literally just not hold elections. No, like a state could literally because as we've said, it's really the electors of a state that vote, right? The state could just say we're not actually holding an election at all, and the electors can. Like an elector can probably just do a write-in candidate if he wants, or the state legislatures can just dictate to the electors. Actually, I don't know if that would violate the Constitution if the state legislature could dictate to the electors who the electors vote for, but.
So, I'm sorry, ask the question again. I had a few thoughts that got tangled.
I guess I don't. Like states don't even have to technically hold elections inside their state, right? They really just have electors that vote for people. The states were just decided to hold elections to tell the electors who to vote for. But
yep.
Yeah. So I don't know, this idea that, like, I know that there are some qualifications that you wouldn't be able to put for president that would fail under like equal protections. Like you couldn't say no black people on the ballot or no white people on the ballot or something. But I don't see how any part of this argument is. It's like backing up, like all of these things that are enforced at the state level, all of these things come from the Constitution. So I don't know why Section 3 is so much different. But you're saying that you feel if it was adjudicated that it would all be ruled differently.
I think that if somebody said black people couldn't, be a congressperson, that would fail on a number of constitutional grounds, equal protection, et cetera. But it would also be adding a qualification for the office that doesn't exist in the constitutionally created office in the Constitution. It would fail on those grounds.
Oh, sure. Okay. Yeah. But Section 3, I mean, it's part of the Constitution, right?
Right. Yeah.
So why wouldn't you be able to exclude somebody based on what's in the Constitution?
Again, so we're mixing the qualification to hold the office and the qualification for the ballot. And I think we have to keep those two things separate in our minds.
Well, if you want to keep them separate, we can keep them separate, but those things are fundamentally different. Like that's a fundamentally different discussion. I think for all intents and purposes, I think that we agree, or I think that people agree that like whether you can appear on the ballot is going to be congruent with whether you can hold office, right? Like, I don't think any state is going to list somebody on a ballot who can't hold office because of some provision in the Constitution.
See, I just disagree with it. Let's come up with a hypothetical and just indulge me in it if you would.
Sure.
So let's say somebody has forged a birth certificate and is actually 24, and they present to the state, their certification that's notarized that they're 25, and et cetera, et cetera, et cetera. That person is not qualified to hold that office, but they have managed to qualify for the ballot.
Okay.
Now, if they get elected to that office and they have the disqualification constitutionally, that they are still not qualified to hold that office. And so the remedy would be that they are removed via writ quo warranto.
Removed how?
A writ quo warranto. That is a common law writ by the federal court of competent jurisdiction, probably the DC district court.
Sure. I don't know if this is 100%. I don't know 100% how this relates to it, but if I follow you on this, like issuing that, so you're saying the federal government would have the authority to issue that, but after what process? That would have to be adjudicated, I imagine, right?
It would be, there'd be some sort of court case. I don't know what the exact cause of action would be.
Now we're back on, well, the cause of action would be what that it was violative of this part of the Constitution, right? But this writ quo warranto would only come after adjudication, I imagine, at a federal court. But now we're back on process and procedure again, right? Which, if you want to, again, I'm sympathetic to the idea that the process or the procedure is difficult, but that's the question of how do we enforce it, not should it be enforced, right? How do we enforce a thing versus should a thing be enforced are two fundamentally separate questions. I think the Supreme Court did this too, and I feel like it's happening here, where we're confusing the how do we enforce this, and it's confusing, therefore we shouldn't enforce it, which I think is unconstitutional, right?
See, I fundamentally disagree with you with your statement that the Supreme Court said that the 14th Amendment, Section 3 cannot be enforced.
Well, no, hold on.
Not what they said.
Sure, that statement is not true. That is not what they said. That's a hyperbolic statement by me. What they said was that they required a law from Congress in order to enforce it, which is adding language to the amendment, which I think is not. I think that's not okay. I think they said.
Can you provide me with the page number of that? I want to see exactly how they phrase that.
Hold on, let me. So I think I'm starting at around page 10. Instead, it is Congress that has long given effect to Section 3 with respect to would-be or existing federal office holders. Shortly after ratification of the amendment, Congress enacted the Enforcement Act of 1870. That act authorized federal district attorneys to bring civil actions in federal court to remove anyone holding non-legislative office, federal or state, in violation of Section 3, and made holding or attempting to hold office in violation of Section 3 a federal crime. In the years following ratification, the House and Senate exercised their unique powers under Article 1 to adjudicate challenges contending that certain prospective or sitting members could not take or retain their seats due to Section 3. And the Confiscation Act of 1862, which predated Section 3, effectively provided an additional procedure for enforcing disqualification. That law made engaging in insurrection or rebellion, among other acts, a federal crime punishable by disqualification from holding office under the United States. So this is giving examples of how the Congress has used laws to enforce Section 3 in the past.
Right. They're going to have an operative statement. And I'm looking for that, and I'm saving you some breath here from reading their, pedantic nonsense. Okay, more of a permitting. Okay, because it limits congressional Section 5 limits because to comply with it. Okay, we're almost there.
The final
content. I'm sorry.
No, you're good. No, it's great content. We're doing all this reading bullshit. So if you look at the last paragraph of the opinion, all 9 members of the court agree with that result. Our colleagues, writing separately, further agree with many of the reasons this opinion provides for reaching it. So far as we can tell, they object only to our taking into account the distinctive way Section 3 works and the fact that Section 5 vests in Congress the power to enforce it. These are not the only reasons the states lack power to enforce this particular constitutional provision with respect to federal offices, but they are important ones, and it is the combination of all the reasons set forth in this opinion, not as some of our colleagues would have it, just one particular rationale that resolves this case. So they're saying that only the Congress can pass laws basically doing something.
Right. So what they're saying, they did not say that the 14th Amendment cannot be enforced. They're saying that state courts and the state governments are not competent to enforce this disqualification.
Does competent mean something different legally here? Or when you say competent, do you just mean like jurisdictionally?
Jurisdiction.
Okay.
I'm sorry. Yeah, I try not to speak in legalese, but sometimes it sneaks in.
That's fine. Yeah. Okay. Okay. Yeah. Yeah, that might be what they're saying. And I agree that that's what they're saying. I think I said that's what they were saying. But then my issue is we don't feel this way with any other constitutional requirement to be listed on a ballot for president.
See, I mean, and I did we say that last bit one more time? I'm sorry.
No other constitutional requirement is treated the same way. This one is being treated uniquely compared to every other constitutional requirement to be president of the United States.
Okay. Right. So I don't necessarily disagree with you on that. I think that there's a qualitative reason for that. And so again, I have a problem with states doing the preemptive work to disqualify somebody from the ballot on the grounds that they're disqualified federally. And I think that
but that's what every single state does with every single qualification.
I'm not disagreeing with you. And I think, let me ask you this, would you disagree that if we follow their logic all the way to the end, that the state doesn't have the power to keep somebody off the ballot if they're 21?
Correct.
Right. Okay. Right. So we're in agreement there. And I
don't think the Supreme Court would say that if it were to come to, if somebody were to run for president who's 30 and a state was like, well, we're not listing you on the ballot, and they were to challenge this up to the Supreme Court, I don't even think they'd take the case. They would just laugh at it and hand wave it.
I don't disagree with you.
Well, but then it's hypocritical. Then they're not applying the law fairly and evenly like a Supreme Court judge probably ought to, no?
If I were the Chief Justice, I would say we got to take this case. But I don't disagree with you that functionally that's the way that it would be, the outcome would be. But I think that we have to get back to your claim was that I think you said threw out the 14th Amendment.
Yeah.
Section 3. And
sure.
I don't find that
they
in here.
Yeah, they didn't throw it out. I'm being hyperbolic when I say that. They didn't necessarily throw it out. But they have basically made it separate from the way that every other constitutional requirement has been enforced when it comes to keeping someone on the ballot. So in effect, they've thrown it out because there's never going to be a Congress that's going to pass legislation to keep like a particular candidate off the ballot. So in effect, it's basically defunct now.
I disagree with you. If it came out that somebody was actually 32 or, let's say 27 and a senator, there would be a writ quo warranto issued and that person would be removed from office.
Issued by who?
There would be I assume it's the district court.
Oh wait, you're saying if they've already been elected to office?
Yes.
Sure, but wait, but that's not. We're not talking about that at all. That's no question for anything. That's once they've already passed all of these qualifications, right? We're talking about to be listed.
So I disagree with you. You're calling. I guess I assume you're saying being elected to that office counts as a qualification for that office. In that.
No. I'm saying we're doing. Okay, this happens a lot. I don't know why this is happening. You're getting hung up on process and procedure. I have no issue. We can talk process and procedure. That's fundamentally different than the law. They've changed the law because they think that the procedure is difficult. That's what's happening. But now when you're talking to me about like, how would you get rid of somebody who didn't qualify for an office? Well, there's a number of ways we could imagine them. And yeah, issuing a warrant from a court could be a way to do it. Maybe there's a subcommittee in the House or the Senate that does it, or maybe there's some order or whatever, maybe but that's not an interesting question. It's not an important question. And it's not it's not the question of the law, which is what this question was supposed to address, right?
See, I think that maybe we're talking past each other on this. I think that let's forget all procedure. And again, back to the light switch. Is this person qualified to hold office or not? Mm-hmm. What is the method to determine simply qualification under the Constitution, irrespective of elections?
None of that is listed in the Constitution. So the assumption would be that it's left up to the states.
No.
Why?
No.
We literally have a federal government of enumerated powers or whatever. Or no? No,
because if somebody is disqualified from being in that office does Colorado have the right to send a federal agent, or excuse me, a state agent to Congress and tell them to leave?
No. But you're talking once they've been elected and have assumed office. Once they've assumed office, it's out of obviously the jurisdiction of a state. But we're talking about access to a ballot and to be elected by the state. Like, how can they keep somebody off of a ballot, right?
Right. And so I think I can tie this all together here. I don't like doing it, but we're going to do it just for the purposes of having a good substantive discussion, which, by the way, this is meant, and I appreciate it.
Mm-hmm.
So the disqualification for the office, so this is the office part. Here's the constitutional question. They're saying you do not meet this criteria here, so we're severing your ability to access the rest of this to get there.
Correct.
And so the question is, does the state court have the capacity to answer this question up here that empowers them to sever the rest of the connection between that person and the office? Does the state have the power to unilaterally determine that this person is disqualified on a constitutional ground, thereby enabling the state to come in and sever the electoral connection?
Yeah. And actually, we can think of this very simply. Not only do they, because they do for every other thing, if they didn't, you would effectively be saying that the states don't have the power to enforce any access to the ballot as far as the Constitution is listed, because then at this point, you're basically saying that the only remedy for this situation is adjudication in a federal court once the person has been elected to office. Isn't that like the alternative to what you're suggesting? If you're saying that a state can never control ballot access, well, then what do they control? Does that mean that you necessarily... So let's say that somebody, let's say Obama wants to run for president again. By your logic, states are required to place him on the ballot, and the only remedy we would have is once he assumes office, then the federal courts can do something about it, which is... And I mean, like, the federal courts are under the president, right? So that's already a very... Actually, yeah, that's self-defeating. That wouldn't even be possible, right? So...
Well, I mean, obviously Trump has appointed his judges, et cetera. But I mean, I get what you're saying. It's messy.
No, not judges, because the judges would have no say in this, right?
Yes, they would.
Why?
They would have a say in adjudicating the claim as to whether
adjudicating the claim. Wait, adjudicating the claim. Yes, but who's bringing the claim? It's federal standing, so it'd have to be a federal court. It'd have to be a federal prosecutor, which exists as part of the Department of Justice, which is under the executive branch. So you'd be relying on the president's Department of Justice bringing this claim to a federal court against himself. No,
this would be civil, not criminal. So if it was criminal, if for whatever reason holding office that you weren't allowed to hold was criminal, then yes, it'd be a prosecutor.
How would it be civil? Wait. Who would have standing for a civil case of this?
And so it would probably be the losing candidate or something. And would have standing. I think that the federal standing rules are problematic too, but that's another discussion entirely. So it would probably be the candidate who lost the election.
Would have standing to bring a constitutional challenge to a person being on a ballot?
Not on the ballot, assuming the office.
Assuming the office? I don't know what individual. I don't know. I mean, obviously, this is all like hypothetical untested law, but I don't know why they would have standing to bring that case. It's not like.
Because the federal, I dislike the federal standing rules. It causes a whole lot of other corollary problems other than this one that we're discussing right now. But let's just assume that by statute, the losing candidate has the right to challenge.
Well, sure, but now we've assumed away the hard part. Obviously, if Congress passed a law for something, then sure. Backing up from all of this, it seems like the obvious answer is just you have to control access to the ballot because that's the only way. Like here's an example. Let's say that I'm 34 and I run for president and I lied on my thing, and then I get elected president, and now I'm 35 and somebody wants to challenge me being in office. Why? I'm qualified. I am 35 years old now, right?
So ask that again. I'm sorry, I was thinking.
Yeah, let's say that I turn 35 while I'm in office, and now I am qualified to hold office. So now you can't remove me from office because I know that
it'd be moot at that point. Once you turn 25, there'd be no adjudicable issue.
Yeah, but like this is obviously kind of nonsensy, right? Like this wouldn't work in practice, right? Because now we'd be encouraging people to try to run for office and get there just so that they could be president and then either outlast whatever the qualifying things are, whatever. Like.
And so, look, I mean, I love the Constitution, but I don't think that it's infallible down to the last detail.
We're not saying it's infallible down to the last detail. This is very clear and plain and obvious. I feel like this is only complicated because we're making it complicated because we wanted Trump to be on the ballot, right? Otherwise, I think this is like pretty clear and unambiguous. Nobody looks at the 22nd Amendment and thinks like, well, it says no person shall be elected to the office. It doesn't say anything about that being on the ballot, so we can have them on the ballot and then they get elected, and then it's up to Congress to address.
Does it say elected or hold? I don't know. And I'm not trying to be difficult.
No, sure. It says no person shall be elected to the office of the president more than twice, and no person who has held the office of president or acted for more than 2 terms to which some of the shall be elected to the office.
Okay. Yeah, I wasn't being difficult, but the language made a difference, but it doesn't matter because I was wrong. So I don't disagree with you that kind of the consequences of following this train of logic to its natural conclusion results in a mess. I don't disagree with you on that. I think that that's a function of the way that the Constitution, et cetera, is written, and states have power to do the not the time. I don't even think they have the time, but it's the manner in which their elections are held. And so to read into that empowerment of the states that they have the power to exclude the president from the ballot when the president isn't even on the ballot. Nobody has ever voted for Donald Trump or Joe Biden or Kamala Harris. Do we agree on that?
No person has?
No person in the history of the United States.
I'm going to disagree with you incredibly semantically, and I will say, yes, they have, because the electors are people. But I understand what you're saying. Yes.
Right. And so in theory, the person to assume the office of the president isn't even on the ballot.
Sure.
Nobody
they're not on the ballot for the citizens of a state, right? They're on the ballot for the electors, though. Yeah.
Yep. Yeah. Mm-hmm. And so maybe there's something where the court says that the electors can't vote for this person because they're disqualified. But I think that we've got ourselves into a big mess in terms of practice, as you keep referring to. Well, the practice is if they're not old enough, they don't get on the ballot. The state determines that. We have a big problem with practice that's built up over the years because we all of a sudden assume that we vote for president when nobody has ever actually cast a vote that in a substantive way for anybody.
What else? Like, what else has this ever resulted in a problem in, though? Like, I don't see all these problems resulting from this. It feels like people are just mad here because they wanted Trump to be on the ballot.
Well, I don't want Trump on the ballot. I want the electors to be on the ballot. And
no, I'm saying on the electors' ballot. That's the only reason why this is a problem. Otherwise, I don't see all these issues where people are like, oh, God, can we really exclude somebody from the ballot because they're 30 years old? California didn't have an issue doing it with Cenk, as you pointed out. I'm sure other people have been excluded from ballots for a number of reasons. But this just wasn't a problem for anybody else ever. Like, it seems like, well, you're saying that this is a huge problem because of all of these issues. I don't think it was a problem until it affected Trump, and now it's a problem.
No, I hear you. I'll even cede that side of the argument that it has only been brought to the fore in this context because Trump as a human being and Trump as a candidate for president. I don't disagree with you. This is a unique iteration of this. Now, let's assume, if somebody was 30 and everybody wanted them to be president, would we have a similar issue? I mean, maybe.
I don't think we would have an issue. I think that what would happen is I think they would be disallowed from the ballot. They could try to challenge that up through federal courts, and they would probably say like, well, no, it's the state legislatures that have the ability to choose the time, manner, and place and how they hold elections, and that includes access to their ballots, as long as they're not making additional requirements that aren't found in the Constitution, as per that Supreme Court case. And then they would just say like, no, we don't need, there's no federal adjudication needed here. This is up to the states to decide. They've decided fairly, and you're done.
I mean, so if we move this out of the present, let's just talk about Congress, because you actually directly vote for Congress, et cetera. So we move it out of the federal courts. So again, and maybe this isn't a discussion where we can come to a resolution on, or even find an acute disagreement, because I actually believe that the Supreme Court's logic ought to be followed all the way through to the end, which is that any determination that any person cannot hold that office and thereby precluding them from being on the ballot ought to be a federally determined questioned by a federal court of competent jurisdiction.
So every single time somebody wants to be listed on a ballot that would contradict the constitutional requirements, you think that that should require federal adjudication?
If a state is going to keep them off of the ballot, there should be some mechanism that is federally determined, because this is a federal office. And there's some hearing or something, and it's show your birth certificate, whatever, and bang, gavel, yay or nay, the switch is flipped. There has to be a federal court to determine whether that person is.
Oh, sure. I don't disagree. But again, we're asking a slightly different question here, because the job of the federal court at that point, even though it seems similar, I think is quite different. If you were to be disallowed from the ballot because you're 30 years old in the state of Florida, and you challenge that to a federal court, or you challenged it up to a federal court, and the federal court looked at that, I think that they maybe should adjudicate it there. But the federal court is not saying that we affirm that you are indeed 30 years old and now you're kept off the ballot. What they're really saying is that the state has the determination to make this decision. The state has determined that you're 30 and now you're kept off the ballot. All they would do is make sure basically that the state has followed the process that the state has, and they haven't violated their own Supreme Court or their own state constitutions or laws. And as long as they followed their process, then they'd be kept off the ballot. But it wouldn't be like the federal court taking over the issue and changing it to them making the decision. It would just be them affirming that the state has followed their own state constitutions and courts. Okay. So even though it seems like they're ruling on the same issue, it's a different matter of what the court is ruling on exactly, I think.
All right. So look, I think that we've I think that we actually agree on perhaps more than we might appear at first blush. Do you want to get into engaged in insurrection? Because I also vehemently disagree with you on this.
Sure, if you want to, sure. And so far as Section 3 is concerned, or just the concept of it?
I'm the facts on the ground. Do Trump's actions qualify as engaging in insurrection?
What do you mean when you say engaging in insurrection?
Oh, that's a good question. So is what Trump did in the lead up to January 6th, do those actions qualify as engaging in insurrection for the purposes of the 14th Amendment?
Yeah, I would say quite easily, yeah.
Okay. And so my question to you is, what specific acts of Trump's qualify as engaging in insurrection?
I would probably just copy what the three things that the Colorado Supreme Court laid out in their argument for it.
Okay. And so, and so that gets into what is the definition of insurrection, right? And so sure. There was that whole historical discussion. Again, I'm working off of memory at this point. But what of Trump's specific acts constitute engaging in insurrection?
Engaging in insurrection, well, the historical argument, funnily enough, is that engaging or supporting an insurrection is kind of like the same thing. If you support an insurrection, you've essentially engaged in it. Now, whether or not that is the case, thankfully, the framers of the 14th Amendment don't have us guess at that, because they literally put that language in there where it's shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. And the historical examples for given aid or comfort to enemies engaged in insurrection is quite extreme. I think the most extreme example listed in that, the Stokes and Paulson paper, are I think a guy gave a Confederate soldier or something $20 before he went south to go and fight in the war, and that person had been considered as engaged in or given aid to the enemies of an insurrection. So I mean, Donald Trump making a speech where he riles everybody up could probably be seen as giving aid or comfort to the enemies of. Tweeting out supportive messages while the rioters were engaged in insurrection could probably be seen as giving aid or comfort to the enemies thereof. I would say these two things qualify pretty easily. Yeah.
All right. So we're going to engage in a bit of a line drawing exercise. So random person attending the speech at the Trump speech, did that person engage in insurrection?
Random person there. If he was just at the speech and he wasn't part of the riot, then probably not. Okay.
And so somebody who was standing outside of the Capitol but not engaged in violence did not enter the Capitol, but part of the general crowd and fracas. Did they engage in insurrection?
I don't know. I'd have to know more about the individual. But it's also really important. You know this, right? It's very important to, are we talking about have engaged in like a crime, or like would we colloquially say have engaged in insurrection? Because these are two very different things, right? Like if I were to tell you that like you incited these people to go and harass me, or you incited these people to attack me, that's a lot different than like, did you engage in the crime of incitement, right? These, like we would use one colloquially a lot differently than we'd use the actual crime of, right?
Fair enough. And I try to make everything in English, not legalese. So that's the general precept. So if you feel like I'm out of that, ask.
Yeah.
So
I'm just clarifying that. Yeah.
Right. So is the person who was near a melee, maybe even yelling stuff at the cops?
I would say, based on everything that happened there, I would say anybody that was in any of the restricted grounds, including the outside area, all had engaged in insurrection as a blanket statement. Yeah, pretty easily.
Okay, so if you're standing in a restricted area and did no other act, how does that qualify you as having engaged in insurrection?
Because you're there as part of a crowd to engage in violence or intimidation, and part of what you're doing is obstructing a federal proceeding. In this case, it was the certification of the vote.
So if you're standing in a restricted area, how is that obstructing an official proceeding?
Because you're a part of a crowd that is there with the intention to obstruct that proceeding, and you're part of a crowd engaging in intimidation.
So is any person that is unauthorized to be in a specific area while an official proceeding is going on, is that person obstructing or attempting to prevent the official act?
Probably not. But if they were marching down the street with a bunch of people chanting 1776, which is a reference to another famous insurrection, while also all screaming about how they were going to stop the certification of the vote, who was there because they were invited by Donald Trump for a historic protest to stop the vote, I would probably say that all of this speaks pretty easily to the intent to obstruct an official proceeding, which was the certification of the election. Yeah.
So if you're marching alongside somebody who is screaming about stopping the certification and they're intent on doing it, is the person who is walking alongside them perhaps not, obviously if you disagreed, you'd run away or whatever, or maybe say, hey, stop that, right? They didn't go that far. But if they're walking alongside because they think that there ought to be pressure on Pence or whoever to not certify the vote, is that person engaging in insurrection?
Yeah, I would say so, of course. Easily, yeah.
Is anybody who wanted to or took actions towards pressuring Pence to not certify the election engaging in an insurrection?
Engaging in an insurrection, anybody? No, probably not. Okay. It was the Paulson and Stokes have 4 things I think they list in their paper. I think the Colorado Supreme Court went with 3. I think one is being part of a crowd, I think, or the crowd might have been the 4th one that was left off. 2 is like either utilizing violence or the threat of intimidation to utilize violence. I think 3rd is obstructing an official proceeding, some sort of federal proceeding.
4 is for a public purpose.
And then 4 might be for a public purpose. One of these, the Colorado Supreme Court dropped. But so like if you tweet out like Pence shouldn't certify the vote, right? You're missing a lot of the parts of that there. So yeah, or if you send like an angry letter to Pence and you're like, fuck you, like I'm going to show up with some friends and beat you up or whatever. I don't think you're engaged in insurrection in that sense or something. Like, so there, you have to meet, these are all elements of a crime, right? They're all required. So for it to be considered insurrection, you would have to meet all of these elements, right?
Sure. And you need the mens rea, which is the intent. But right. And so you'd have to meet elements. But again, we're not talking about criminal prosecution here.
Oh, sure. I'm sorry. I'm just using.
Yeah.
But no, I'm saying you would need to hit all of these like points for it to be considered insurrection. Otherwise, it could just be considered a crime, or I shouldn't say crime. It could be considered bad, or you're like bullying or intimidating or whatever. But intimidation on its own is not an insurrection. Obstructing a federal proceeding on its own is not an insurrection. Like if I run into a building and I pull a fire alarm to get them to all run away, maybe I've done bad things, maybe even criminal things, but I don't know if that would be an insurrection. There's no intimidation or violence part, right? You would need all of these things to be considered. Yeah, go ahead.
So I'm going to ask you something that seems almost out of left field, but I'm going to work backwards towards tying it back together. So was there a cognizable legal argument that Pence had the authority to not certify the electoral vote tally?
No.
Then why did Congress change the law to clarify the ambiguity?
Because they felt like they wanted to, but that's not necessary for me to know if there was a legal argument for it, because I can see the arguments that Eastman and Trump made for it, and the arguments they made for it all revolved around breaking the law. So if there were legal ways to do it, all of the arguments wouldn't revolve around breaking the law. Are you aware of any arguments that they put forth that didn't involve them breaking the law?
Well, the difference is there a legal ambiguity?
If there's a legal ambiguity, then you wouldn't speak to breaking the law, right? The ambiguity that they thought was a conflict between the law as written in the Constitution, which is a determination for the Supreme Court to make. But if you want to appeal to the Constitution and break a law, you're breaking a law. So you know you're committing an illegal act, right?
I don't disagree with you. So why did Congress change the law in response to January 6th?
I think they clarified some role of the vice president.
Right. They clarified. Do you clarify something that's clear, or do you clarify an ambiguity?
You could clarify an ambiguity, but that doesn't change the fact that they weren't abusing an ambiguity before. They were trying to break the law. They didn't say there's an ambiguity in the ECA that we think we can utilize to have Pence reject the election. They're saying this is where we break from the ECA. This is where we part from the ECA. This is where we appeal to the Constitution and break the law. And that was all of the plan. That's what they wanted to do, right?
Well, if a law says that if Congress passes a law that says we shall establish a religion, is that a valid law?
I mean, if it's passed by the Congress, yes, right?
Oh, really?
Yes.
Even though the Constitution says Congress shall pass no law respecting an establishment of religion, is that a valid law?
I mean, yeah, you would have to challenge it through the Supreme Court, and it would have to be struck down by the Supreme Court, right?
I completely fundamentally disagree with you.
Okay, so then are you telling me that a citizen is the one who's able to make constitutional interpretations to determine what's legal or what's not legal?
Well, that's popular constitutionalism. I'm not getting into that.
Okay.
What I'm saying is your statement is that the Electoral Certification Act created a potential conflict, and there was ambiguity that was clarified. I
don't think there was ambiguity. The Congress passed a law to clarify things because they felt like they wanted to, or whatever. But I think it was pointless. I don't think there was any ambiguity at all. And Eastman and Trump also, and Chesbrough, none of those guys thought there was ambiguity. They all understood that they were breaking the law. That was the clear and unambiguous language that they used in every single memo. We're going to break the law here. Right.
So what is superior to the law? Is there any body of anything that's superior to the law?
Like laws from Congress? I mean, the Constitution powers all three branches of government, right?
Right. So the Constitution is superior. And so is a law that is in conflict with the Constitution a valid law?
I mean, you're begging the question, who determines if it's in conflict with the Constitution? The Supreme Court, right?
That's a procedural question. I'm asking substantively, is a law that is in conflict with the Constitution a valid, enforceable law? In theory, not procedurally.
You're saying in theory, not procedurally, but now you're asking me about enforceable. I mean, enforcing is procedurally, right? If a law is invalid because, or I'm sorry, I mean, theoretically, but in just theory, if a law passed by the Congress violates the Constitution, then that law is not technically a good law or not a valid law. It should be struck down by the Supreme Court, right?
It should be struck down by the Supreme Court. Why should it be struck down?
Because the Supreme Court would look at that law and they would say that this is violative of the Constitution.
Right, and the Constitution is superior to the law.
Sure.
Right. And so is it your position that there was no ambiguity at all whatsoever between the Electoral College Act and the constitutional mandates?
Yes.
So you think there was no ambiguity at all?
Correct.
And so why did Congress pass a law to make it better fit the Constitution?
I don't know. Ask them. What part did they change that you felt was ambiguous before?
I don't know the exact specifics. I just know that
when I read through it, I
rationale.
think they changed a little bit, clarifying the VP's role, but like I don't think there was any ambiguity at all. Also, neither did Eastman, neither did Trump, neither did Chesbrough. They didn't think there was ambiguity. That's why they all said they had to break the law. And that's why we've used this law for like 150 years without any prior conflict. In fact, we are so confident that this law is so constitutional and so important that we shut down a recount in Florida in Bush v. Gore in order to maintain that safe harbor date for the December 15th electoral vote count. So I think that the entire United States felt like this law was like pretty rock solid, and that's why it was followed like basically to a T for like 150 years. I don't think anybody thought this law was unconstitutional or vague or weird.
Well, then you've got a bone to pick with the Congress then.
Maybe, but that's a different question fundamentally, right?
Okay, well, so in your world, there was no ambiguity. However, in the eyes of the Congress, there was an ambiguity, and that ambiguity was clarified as you stated, correct?
Sure.
In the eyes of the Congress, right. And so whether or not you, Mr. Bonelli, have a conflict or not, I was hoping you would laugh at that reference to Finkelstein. It's okay. Just because you believe that there's no ambiguity, however, the lawmaking body has at least felt there was enough argument there was an ambiguity to change the law to eliminate the potential ambiguity, correct?
Yeah, but I don't think there was an ambiguity, right? You can't state an ambiguity. I've never had anybody state where they thought it was ambiguous. And even if I were to grant you all of this, you said that you have a private practice. If I came to you and I said, hey, I think that this particular law, I think actually is violative of the Constitution. Can you help me how to break this law? What would you tell the client?
Have you ever heard of Rosa Parks?
Sure.
What did Rosa Parks do?
Broke a law?
Uh-huh.
Okay. You understand the difference, right?
I'm not.
Do you know what the crime fraud exception is, right? So you know there's a huge difference between you as my lawyer advising me on how to break a law versus me getting you as a defending party, as a defense lawyer after I've broken a law, right? That's a huge difference, right? One of these, you're implicated in a crime, and another one, you're just my defense in court, right?
That's okay. So I thought you were talking about a theoretical level, not at an attorney-client level.
Oh, sure. Yeah. Well, I'm just saying that so Donald Trump and Eastman and all these other people, they were breaking the law. They knew that, right? They might think that it's not constitutional, fine, but they're breaking the law. And they said they were breaking the law. And so if you're breaking the law, there might be penalties there. Like you might go to jail, you might go to prison. Now, maybe ultimately you'd win a case and the Supreme Court would throw out a law or something. This didn't happen, but they were all breaking the law and they knew they were breaking the law. And that was what they were doing the whole time, right?
Right. So it depends on your jurisprudential school of thought, but
there is no jurisprudence where a lawyer can help a client or give a client advice on how to break a law, right? In the United States. Right. Okay.
I don't disagree with you on that, and I'm not taking a position on Eastman's actions as an attorney. But let's just zero it in on Rosa Parks. Let's assume that Rosa Parks read a bunch of laws and is not an attorney and came up with the idea to do what she did.
Sure.
Right. And so, yes, Rosa Parks broke a law, but and this might not be the best example.
Because it's going to agree with all my points entirely. Because she probably
yeah. No.
Okay.
No, but was she ultimately forced to serve a sentence? I mean, after the law was struck down? No. The law was ultimately struck down, right?
The law was struck down, correct. Yeah.
Right. So while the law was still in effect, but ultimately that law was invalid.
But notice earlier you asked me about the enforceability of an invalid law. It is enforced while it's invalid, right? If you break the law while it's the law, that's why it was confusing when you asked me the question.
No, and I agree with you. That was enforceability is a separate question as to the theoretical validity of a law. So
but to be clear, enforceability is not even a question. Enforceability should always happen for the law. And it's not up to the executive to decide if a law is enforceable or not. That's literally a constitutional crisis, right? Like if the
that's called that's called prosecutorial discretion. That happens every single day. An executive
deciding whether or not they want to prosecute an individual is not an executive deciding whether or not a law is enforceable. If they decide that they're not going to enforce a law as a blanket statement, you have a constitutional crisis. It's an issue, right?
You don't think that there are policy positions of prosecutors to not prosecute a certain set of crimes?
I mean, if they're making these decisions outside of what they've been statutorily authorized to do from the legislatures, I imagine they could either be impeached. I don't know if you could be charged for crimes there, or you'd be elected and thrown out of office. But no, I mean, I think none of us should want the executives to be able to make their own laws or decide which laws to enforce or not. The goal of the whole job of the executive is to execute, right, the laws from Congress, right?
Right, but the entire, if everybody was prosecuted for every single potential violation of the law, that would be completely anathema to our system. And so that's why we have elected officials and not robots and AI running the judicial system, is because you have that discretion built into it.
Well,
by
hold on.
nature,
Discretion is discretion.
We're getting far afield, but I'm actually enjoying this.
Sure. But discretion is fundamentally a different thing than whether or not you think a law should ever be enforced, right? Like there'd be a difference between a cop being like, fuck me, like I'm not going to pull this guy over who's going 6 over on my radar. I'm going to wait for somebody else, versus like a police chief and then a mayor and then a governor all saying, listen, we're not going to pull over anybody who exceeds 7 miles per hour in the speed. We're not doing that anymore. That blanket statement, like the legislature be like, excuse me, that's not your job to say that. You're not allowed to say that. That's insane. That's a lot different than a cop or somebody or like a DA being like, okay, we're going to cut this guy a plea deal or whatever. Like these are different types of things, right?
No, I disagree with you. Unless there's a law that says it's illegal for the prosecutor to not enforce a blanket set of laws, they have that discretion. Functionally, they have that discretion.
Okay, I agree that they have discretion, but I think discretion is a lot different than an individual agent acting versus like a rule set by an executive, right? So like it is the fact that right now speeding is illegal or misdemeanor or whatever. Or no, misdemeanors are illegal.
It's a civil infraction.
Actually, it might be an infraction. Actually, it might not be illegal till 15 miles. We'll say 15 miles per hour. Yeah, reckless driving is illegal. It's either a misdemeanor or a low-level felony, depending on how reckless you're being, I guess, is illegal in a state. Cops don't decide that it's not illegal. They might just execute some discretion on whether or not they enforce it. But like, there's a difference between individual actors versus like a DA or an attorney general saying we're actually not going to enforce this particular body of crimes anymore.
So if a prosecutor decides not to charge a specific person with a crime, is that them choosing not to enforce that law?
It would depend on the rationale. But if they decided not to prosecute anybody based on that crime, I would argue that would be improper. That's like I would
agree with you that's improper, but I think unless there's a statute that punishes that or calls for their removal, that's within their discretion. That's part of the whole reason why you have the elected person serving in the office, is so they are capable of using that discretion.
I disagree. I think we elect executives to execute the law.
So you think that we don't elect the executives to use discretion?
I just don't think discretion is the same as rulemaking.
I don't disagree with you. Those are fundamentally different concepts. However, the whole point of having a person elected to the office, you're electing them for their policy positions writ large, et cetera, but you're also trusting their judgment and their discretion.
I guess I just don't think so. I don't think like discretion to like perform their job, but not discretion to like enforce the law. If that is happening in places, then that's bad. You should never be electing your executives for how you want to enforce the law. That's what the legislatures are for, is to write the law, right?
No, the executive is to enforce the law, and so you elect executives who enforce the law in the manner that you see better than the alternative.
Okay, but the enforcement of the law shouldn't be choosing whether or not a law is enforced. It's choosing how to enforce it. That's what a rule is versus like a statute from Congress, right?
Right, and choosing to only enforce it if it's 20 million parts per million or 20 parts per million versus 400,000, that is built into the discretion there.
Not only is it not built into the discretion, that's going to be whatever the Congress authorizes explicitly. And if anything, the Supreme Court with the Chevron overturning has even taken away from that discretion now and saying that there's only one correct statutory interpretation of any given law from Congress, right? So they've even restricted the federal government's ability to have that discretion, right?
Not exactly. So
no, wait, not exactly how? Yeah.
With Chevron, what was going on was that the Congress was authorizing the executive to make substantive decisions right? And so what that meant was, for example, Congress says you can regulate toxic chemicals, and the executive branch says that carbon dioxide, which is not toxic, qualifies as a toxic chemical because the experts said so, et cetera. And so that's a totally different discussion about delegation of lawmaking is what was going on, and that
Wait,
Supreme
hold
Court
on.
directly overturned that.
I completely disagree that that's what Chevron was about. I think Chevron, or that it's a different discussion, I guess, just for my honesty. But
Let's do it. If you want to go there,
sure. Chevron deference had to do with the idea of if Congress passes a statute, then the executive the executive body is allowed to engage in a little bit of statutory construction. So let's say Congress says, we want you to ban all melee weapons. Okay. Well, the executive looks at this and like, okay, well, fuck, melee weapons. Does that count as like a kitchen knife? Does that count as like a bat? Okay, we're going to ban this whole blanket rule of things. Okay. And then what Chevron said is, let's say somebody challenges that action in court. They're like, the police officer came to my home and he took all of my knives, all of my kitchen knives. I can't cut my fucking sticks up anymore. Right. And you could challenge this all the way to the courts. And what the Supreme Court would say is, the Supreme Court say there was I don't remember the two-step Chevron stuff. There's 2 steps or 3 steps, depending on how you look at it. But they would basically look at it and they go, okay, well, this law was passed from Congress. Is this a permissible, the key word, is this a permissible reading of the law? And as long as it could be reasonably construed that like, yeah, this is probably what Congress meant, then the Congress say, it's fine, it survives, Chevron doctrine. Now, after Chevron was overturned, what the Supreme Court says is actually, for any given law passed by Congress, there is only one permissible statutory construction. It doesn't matter if what the federal government assumed was reasonable. What matters is what we ultimately say how the statutory construction should go. So if we believe that kitchen knives are or are not melee weapons, our decision is the one that will dictate how the federal government ought to create rules around that congressional statute. I thought that's what the Chevron overturning had to be about.
And maybe this is my interpretation being passed from the milieu of legal education, but Chevron deference, what it meant was that so Marbury versus Madison stands for the idea that the judiciary has the final say on what the law is.
Well, when the Constitution says, right?
No, what the law is.
Yeah, but in accordance, Marbury v. Madison was the idea behind judicial review. Wasn't it the idea that the Supreme Court gets the final say on what any law does in proportion with the Constitution of the United States? No.
No,
okay.
It's what the law said, what the law is. That is the fundamental takeaway of Marbury. And so what Chevron deference was it took the Supreme Court said, the lower courts, you do not have, and even with the Supreme Court, very frankly, you do not have the ability to say what the law is. You give deference to the executive interpretation of it. And so that is
as long as it's permissible. So like if the federal government said that we're going to ban guns because we think you can hit people with guns, the federal court, the Supreme Court, could still look at that and go, excuse me, guns are not a melee weapon. This is an impermissible construction of the law. So even with Chevron deference, we're going to overturn this. You can still challenge it. It wasn't always in deference to the federal government.
I'm curious, and this is not a gotcha. I'm curious to watch this happen. So explain to me how the tailpipe regulations of carbon dioxide is permissible under a statute that regulates toxic chemicals. And keyword there is toxic.
I would have to know the particular EPA law. I would have to know the law that was passed by Congress, because my understanding is every single federal rule is supposed to cite to a law from Congress for where that rule gets its power from. So if you can give me the federal rule, I can look up the congressional statute. I think
it's called the tailpipe rule. It's been a while, but I think it's called the tailpipe rule.
Is this March 20th? Is this like a very recent thing?
No, this should be 90s, maybe 2000, maybe late 80s, early 90s.
Because I see a thing about like permission, hold on. This is emission standards. Hold on.
Right.
Environmental Protection Agency, 40 CFR parts, blah, blah, blah. Okay. Multi-pollutant emission standards for model years 2027 and later light duty and medium duty vehicles for the EPA. And this is the rule that was being made. And its summary is under the Clean Air Act, the Environmental Protection Agency is establishing a new, more protective. Okay. So if I look up like the Clean Air Act, I imagine within this act, I'm going to find some part that they're citing to, right? Do you want me to look through this and find out if I feel like this is?
I would love to work through this with you. I think it's going to be instructive. And I'm not doing this as a gotcha. I think it's like incredibly important that everybody understand how this works and the problem.
All right.
I mean, the Clean Air Act is going to be voluminous. I don't know that they're going to give you a specific citation within that act. I can tell you the thrust of it if you're willing to take it on faith, but
I mean, it's going to take me a second to look it up, but I mean, I imagine I should be able to find it eventually. Yeah. I haven't dug through. Okay. Why? So I'm looking up, they started to begin these things back in 2007 is what okay. And they're citing to, so on the federalregister.gov, it's saying, why is the EPA taking this action? And it's saying Clean Air Act, section 213, subsection A, subsection 1. So now we're going to the US Code, which is our laws from Congress. And we've got 42 USC, 7547. Hold on. Is this, I think this is what this is citing to. Okay, and this is saying that the emission standards, A1, emission standards 1, the administrator shall conduct a study of emissions from non-road engines and non-road vehicles other than locomotives or engines used in locomotives to determine if such emissions cause or significantly contribute to air pollution, which may reasonably be anticipated to endanger public health or welfare. Such study shall be completed within 12 months of November 15th, 1990. Okay, so it says that the Clean Air Section 20 directs us to study emissions from non-road engines and vehicles to determine, among other things, okay, which may be, okay. And then section 213A2, after notice and opportunity for public hearing, the administrator shall determine within 12 months after completion of the study under paragraph 1, based upon the results of such study, whether emissions of carbon monoxide, oxides of nitrogen, and volatile organic compounds from new and existing non-road engines or non-road vehicles other than locomotives or engines used in locomotives are significant contributors to ozone or carbon monoxide concentrations in more than one area which has failed to attain, blah, blah, blah. Be anticipated. Further requires to determine whether emissions. Okay, now I'm back to reading the rule. If we determine that emissions from all non-road engines do contribute significantly to these non-attainment areas, then section 213A3, it's not, so it's going through here. So what part of this, I guess, so what part of that federal rule do you feel like doesn't map cleanly onto congressional statute, I guess?
So so I apologize. I didn't want to interrupt you in the middle of that.
Yeah, you're good.
I'm trying to find. I wish I have the textbook over there, but I'm not going to bore you with that. I think it's the Clean Air Act. And did you just quote from the Clean Air Act, or was that from legislation from the original Clean Air Act, or was that a modification amendment to the Clean Air Act?
So I'm on 42 USC 7547. My guess is this part of the US Code is probably part of the Clean Air Act, is my guess. 42 U.S. Code, Chapter 85, Air Pollution Prevention and Control. That's going to be my guess. I mean, I could be wrong, but under Title 42. Yeah.
I'm going to explain the substance, and I'm going to briefly try to find it because I don't want you going down a rabbit hole of something that's off point and it doesn't do any good for anybody.
Sure.
So the resuscitation that I would give on the law school exam is essentially that I believe it's the Clean Air Act. Don't quote me. I'm going to double check for you. That Congress passed a law empowering the regulation of toxic chemicals.
Okay.
And there was a Supreme Court case, and what's it? I remember who wrote it. I see his face. I can't remember. It doesn't matter. They had a whole huge, voluminous Supreme Court decision about whether greenhouse gases qualify as a toxic substance because they are not toxic. There's no toxicity to CO2. It just crowds out the oxygen and you're starved for oxygen.
Okay.
And so the Supreme Court went through a big, long discussion. No, it's got to be Chevron. It has to be the Chevron decision, where the Supreme Court said that the federal regulators have interpreted the toxic chemical, the toxic language, to include greenhouse gases and climate change. And under that deference, we're going to permit that interpretation.
Okay.
Right. And so Congress said regulate toxic chemicals. there is no interpretation of the word toxic that would permit CO2 being qualified as toxic.
Well, that's not true, right?
No, I don't. I disagree with you. It's not toxic.
Or if I put you in a room full of CO2 and you breathe it in, you're going to die, right?
That's not from toxicity. That's from asphyxiation.
Yeah, but I mean, like, if you're
toxic means I eat a kill. You know, like I don't know how toxic chemicals work specifically, but it's very different.
well, how
So-
what different as by whose definition? I mean, like, what is toxic at that point? Like, there's a lot of things that we would consider toxic because they might bind to things in your body that inhibit your ability to absorb oxygen, or it might do things that then would lead to asphyxiation. Like CO2, like if you have, like for instance, when you hold your breath, the reason why you feel so much pain in your body is literally because of the buildup of CO2 in your blood. I think that might even be called CO2 toxicity. So like if you keep breathing it in, I don't know what definitions of toxic. I'm sure we could find different ones.
So toxicity is defined as poisonous. Poison is defined as a substance that is capable of causing illness or death in a living organism when introduced or absorbed. So carbon dioxide in and of itself is not toxic when it is displacing the oxygen to the point where your body can't bring it in. That's true, but that's asphyxiation. That's not toxicity.
So then would you agree then that like, I want to say monoxide. Oh, like carbon monoxide then, is that toxic?
I don't know.
Or is anything toxic? Because we could argue that a lot of things like helium.
Lead is toxic.
Sure.
I'm pretty sure.
But I feel like we could find a lot of things that everybody would say is toxic because it displaces oxygen. But like,
yeah, but that's not toxicity. And so this is the fundamental question here.
Sure,
so
but I guess my guess is going to be that in reading through that Supreme Court case, if this was Chevron, that when you read through the Supreme Court case, what the Supreme Court probably factored into their decision making is if the federal government is making these rules based off the congressional statute, that is leaving relatively wide authority or wide discretion in terms of interpretation. If the Congress is not fighting against the executive, or nobody's making statements about it, or nobody's trying to pass laws changing it, then the federal interpretation is probably okay. That'd be my guess. Was probably part of the ruling there for Chevron, right? Because the idea is that Congress is not going to be able to perfectly delineate the vocabulary on every single rule and every single thing that ever comes out. So the federal government has some leeway, and that can even be defined by the Congress, right? Like you have the ability to do studies to determine if a thing is a contributor to toxicity or whatever, right? Like it's probably okay that the federal government has some being able to determine something here, right?
Well, so the question, and this is back to the same essence of prosecutorial discretion, right? So it's like,
well, hold on, but we got to be so careful. When we say prosecutorial discretion, we're talking about somebody who's been charged with or convicted of a crime, and whether or not how we're going to proceed with that criminal matter, right? That type of prosecutorial discretion is a lot different than the discretion that might be applied when what we're really talking about is statutory interpretation, right?
Granted.
Mm-hmm.
Granted. I'm sorry, and the question preceding that
basically
was,
just that like the federal government is going to have some deference to interpreting things because like every single thing, like what if it was the case that like there was
yeah. So I agree that there has to be some room for the federal executive to be interpreting statutes, but the question
careful,
is,
wait, because now there is no room. Now there's only one correct interpretation, and that's what the Supreme Court says. There used to be multiple.
Right.
Yeah. Okay. Yeah.
And that's what Marbury versus Madison said, right? That's been the bedrock of American constitutional law since 1801 or 2. It is emphatically the role of the judiciary to determine what the law is. And that is the key takeaway from Marbury. And so what the Supreme Court did was they undid Marbury to an extent. They dialed it back a little bit, and they gave the executive branch deference in the interpretation.
Hold on. I don't believe this is what Marbury v. Madison was about. I think Marbury v. Madison was about establishing the concept of the Supreme Court being able to say this law is violative of the Constitution, and we are the last say on that matter. Not them being able to enforce statutory construction on everybody else. No?
This is from Marbury versus Madison. It is emphatically the province and duty of the judicial department to say what the law is. What the
when they
law
say
is.
wait. It is emphatically, because my question is, when I look this up, it is emphatically the province and duty. Are they referring to the law as in statutes from Congress, or the law as in the Constitution?
The law as an entire amorphous concept that is made up of the Constitution and made up of court decisions and made up of statutes and made up the whole thing. And so we're getting into the philosophy of law, which is jurisprudence, which I think is a topic you would find absolutely fascinating. By the way, we probably butt heads in class, but I think you'd find it fascinating nonetheless. And so what is the law? It is the judicial branch's ultimate authority to say what the law is.
Yeah, but when we're saying, I understand, but when we say to say what the law is, you're implying that they were speaking about statutory construction. But what they're really saying when they say what the law is they mean determining ultimately if something is violative of the Constitution or not. So if I make
whether something's constitutional or not is a subset of that, but it's not the entire thing. So a law, they might say this is not a law. The law is not this because it violates the Constitution, but that's not the same.
That is what they were saying for Marbury, though. That's what
there was a big question as to whether the court could issue the writ of mandamus. There were a bunch of other ancillary questions. So actually, the Supreme Court gave the Jefferson administration the win on paper, but what the big thing that Marbury versus Madison did was it created judicial supremacy and finality.
So in looking at this, it is emphatically, so the paragraph before is, if an act of the legislature repugnant to the Constitution is void, does it, notwithstanding its invalidity, bind the courts and oblige them to give it effect? Or, in other words, though it be not law, does it constitute a rule as operative as if it was a law? This would be to overthrow in fact what was established in theory, and would seem at first view an absurdity too gross to be insisted on. It shall, however, receive a more attentive consideration. So what if they passed a law that was in violation of the Constitution? And then the next paragraph is it is emphatically the province and duty of the judicial department to say what the law is. Those who apply the rule to particular cases must of necessity expound and interpret that rule. If two laws conflict with each other, the courts must decide on the operation of each. These two laws being one passed by the Congress versus the Constitution. And then for the next paragraph, so if a law be in opposition to the Constitution, if both the law and the Constitution apply to a particular case, so that the court must either decide that case conformably to the law, disregarding the Constitution, or conformably to the Constitution, disregarding the law, the court must determine which of these conflicting rules governs the case. This is of the very essence of judicial duty. If then the courts are to regard the Constitution, and the Constitution is superior to any ordinary act of the legislature, the Constitution, and not such ordinary act, must govern the case to which they both apply. So I don't think this is about statutory construction. This is about the supremacy of the Constitution over any law from the Congress.
So that is the specific question that they're deciding, right? And is this law that stands in conflict with the Constitution, is it the law, right? Mm-hmm. Yes, I agree that is the specific instantiation of the question. However, I really, unlike other things in this discussion, I do not think I'm out on a limb here on this one. If there are two laws that are conflicting, the judicial branch from Marbury has the same authority to determine the adjudication of the conflict between those two laws.
Uh-huh.
And so that's Marbury. Is at the end of the day, the judicial branch has the final say on what the law is in answering that specific question.
I agree. But this is what the law is when, as you said, for conflicting laws, not statutory construction or interpretation, which is just...
So what happens if you have a rule that conflicts with a statute? It's the same question.
Well, if a rule conflicts with a statute, the rule is thrown out immediately.
Right. By whom?
By the, I guess it would be by the courts.
Judiciary. Bang.
But that's not conflicting law. The executive doesn't deal in... No, it's absolutely not. The executive does not deal in laws. They deal in rules because they can't pass laws, right?
No, well, statute. Here's another big linguistic problem is we use law and we kind of mean statute.
Yeah,
but
law
that's
and
not
statute
all the
are the same thing, right?
No. So the law, what is the law? Is the law whatever the judge decides in that given courtroom at that given time, guilty, not guilty, whatever he decides, regardless of how he got there, or is the law a series of interlocking statutes that extend across multiple fields of analysis all the way up to the Constitution, various jurisdictions?
Well, the
right?
law are definitionally are statutes, right? They're not rules. Yeah.
No, what?
When you're reading jury, what does common law to do with this?
What's the common law? Is it not law?
Isn't that just Louisiana? I don't think anybody else uses
No. Louisiana is the only state that uses Napoleonic Code. Every other jurisdiction in the United States uses common law.
Hold on, wait. I don't know. When we say common law, I would have to. I'm gonna be honest. I don't know this.
It's okay.
No, but when if I get charged with a crime and I go to court, nobody's like talking to me about common law. They're reading the statutes. That's what's being read to the jury in terms of like how to like convict somebody. That's what I'm being charged with. I'm being a crime that can be found in a state statute. I'm not being charged with a common law thing.
But if Virginia, for example, were to repeal all homicide statutes right now, I could still be hauled into court and tried for homicide under the common law. The common law exists only to the extent that the common law exists always unless it is expressly displaced by statute. And so right now we have a proliferation of statutes that have, various iterations of criminalizing homicide statutorily, but the statutes themselves are not the only source of law here.
That might be the case. I don't know what it looks like when there's not. I would be very surprised if I could be charged with a crime by common law if it's not actually in statute. But
yes, that's how it has worked for the majority of the history of the Anglo-Saxon jurisprudence.
I don't know about Anglo-Saxon jurisprudence. I'm only speaking to U.S. law because this is the United States of America, and these are the venues that we're talking about, right?
Right, but what body of law was inherited by the colonies? Did
inherited and then codified into federal and state statutes or into the Constitution, right?
No, I'm not trying to be difficult here. You're not correct on this one.
What is wait? Is there any criminal common law? Can you think of a single case where somebody was charged with a criminal common law thing?
Almost everybody if temporally, almost everybody ever charged with a crime, like burglary is a common law crime. It was created by courts, not by a legislature.
But it's codified in state legislatures.
It is now.
Yeah.
Recently.
How recent is recent?
I would suppose in the last 50 to 100 years, maybe 150, maybe.
Okay. I would have to go and look up like how, because I thought that there was codified criminal statutes, like even prior to the formation of the Constitution, that like even like under the Articles of Confederation, there were states that had codified like.
There may have been, but for example, Texas's Constitution says that the common law of England was in effect as of the date of the ratification of Texas's Constitution is the law.
I think, right, but that was only for gaps that weren't explicitly maintained or dealt with by. Like if you go to Texas and we charge somebody with a crime, they're being charged with a Texas statute. There's going to be a statute that's cited there, not like a random common law thing.
Correct. Yeah. Because the way that it works is if there's a statute that specifically displaces a common law rule, then that statute displaces the common law rule. But it has to explicitly displace the common law rule.
Sure. Okay, I don't know how we got onto common law, but
this is actually one of my I love Anglo-Saxon jurisprudence. It's amazing. It's
also
beautiful.
I didn't know that. Well, as a real quick thing, I just want to say, because I didn't know the conversation would go on so long. I was supposed to leave at 5. So we got like 5 more minutes because I have a flight I've got to catch because I'm going up to New York because I'm doing some stuff tomorrow. So yeah, go ahead. I'll let you, any final points. So we can also talk in the future if you ever want to as well. Yeah.
I would love to. I think this was brilliant. I think this was instructive. But here's my argument in favor of the common law as opposed to statutory law. And so the common law is a neural network of the greatest legal minds that have ever contemplated the same issues over time from 1215 to today. And so you have the same great legal minds working, refining, bit by bit, fixing this thing versus a statute, which is whatever 50% plus one members of a bunch of idiots who are elected to office managed to put down into writing. And so the advantage of the common law is the best people, the greatest minds that have ever thought about this for 1,000 years have been thinking about this and honing the legal rules. Whereas statutes, trust me, I'm going to Richmond next week to help in the legislature part-time. It is whatever 50% of both bodies plus the governor will agree to sign. And so it's like, if you read a lot of statute, like for example, the Rittenhouse case, which is something I know that you were interested in, there was the law, there were two statutes that were just clearly conflicting about his capacity to carry.
Yes, that's correct. Yeah.
Right. And so you have two legislatures at two different years in two different political environments passing whatever the legislative services wrote down. Whereas the common law is a neural network tracing all the way back to 1215, maybe even 966 or whatever.
But statute is generally, we would prefer statutes versus common law. No?
I don't know. I don't think so.
I would want to have a clear and unambiguous understanding of what the law is if my rights are going to be deprived for breaking it. No? I think I would want to know.
But why is it called the common law?
Because there's a whole bunch of jurisprudence that's like basically in normal times has ruled on this thing over and over again. It's like a science thing, sure.
Yeah, exactly. And so perhaps in the modern era, and there are plenty of arguments about the common law being able to keep up with technological innovation, whatever, fine. That's the whole purpose. So in England, the legislature was nested within the courts. And so when the courts, the common law couldn't keep up with the changing legal realities, that was the purpose of the parliament, was to step in and make an instant change to the thing.
But when we're talking about criminal matters, like my rights can be taken from me. I want a very clear, I don't want to be at the whim of a judge to decide what the law is in some particular area. Like I want to have a clear and unambiguous reading of a statute that can dictate what the crime is and what the punishments are, no?
Well, no. So the common law does have, it has elements exactly the same. And so a lot of statutes are attempting to distill the wisdom of the common law and maybe say, okay, maybe we need to have reckless homicide be a thing because it only requires intent to be homicide, right? But they come in and they try to instantiate an improvement of the common law.
Sure.
But the common law is the basis of when you study for the bar exam, burglary, robbery, arson, all these things were developed to common law. Now, some statutes have, legislatures have come in with the model penal code and maybe some other idiosyncratic efforts to reform it. But the common law still is the basis. And so if Virginia were to repeal every homicide statute right now, if I were to shoot somebody outside in front of my building right now, I would be hauled into court and tried under murder by common law. And that's the situation. And I assure you that's the case. And
I'm 100% positive that would not be the case.
You're 100% wrong.
I know I'm correct on this, because if it was that case, like, you don't have to make a law explicitly allowing something to be illegal. You would just have to repeal the statute that makes a given thing illegal. Like, if somebody were to repeal a law on sodomy, they don't have to pass a law saying you're allowed to have anal sex, right? Or you're allowed to have oral sex. They would just have to repeal the law. Part of that common law factoring, I imagine, would probably be like, well, this was enforced via common law, then it was enforced by statute, and now that that statute has been repealed, the assumption wouldn't be that the common law would come back, because the statute was just the codification of whatever the common law was, ideally. Since the statute was repealed, then it seems that the people have decided that they want this particular act to prevail in society, would be my guess.
You're flatly incorrect on that. And I'm
so
not
you're telling me that if a state was to say, we're going to go ahead and legalize chopping down trees because we've decided that we want people to be able to chop down trees, the state legalizes it, somebody would go down to chop down a tree, and then a cop could arrest you and say, common law violation, we got you. And it's like, wait, but they just like decriminalized this act. It's like, yeah, but 200 years ago it was illegal, and now we've got you on common law.
If a statute directly contradicts or displaces common law, then that rule governs.
Yeah, but I'm saying if they repeal the statute where common law once was.
Right. So if you repealed the homicide statutes, homicide is still illegal and criminally punishable without statute. I'm telling you, statutes and law are not a one-to-one thing. And this is a huge misconception, popularly and otherwise. And this is not, I'm not out on a limb on this one. I guarantee you that. I promise you that.
I don't know. I don't know if anybody, like, nobody in the United States gets prosecuted criminally on common law. I don't believe this happens. Does it? It's always a statute that's being cited. It's always a statute that's being argued over. It's
in the modern age. I've got the book right here. Give me. It is called Common Law in the Age of Statutes. I don't see it. Oh, there it is, right here. Oh, I'm wrong. Aha. Common Law in the Age of Statutes. So this is a book arguing, well, not arguing, but kind of just flatly describing the situation where we have this body of law, the common law, that is being routinely displaced by statutory law. But what is the role of common law in an age of a proliferation of statutes? And this is an interesting artifact of the constitutional separation in America between the legislature and the judicial. And I would argue that that's a problem that the founders didn't foresee when they created that separation between legislative and judicial.
Sure. And obviously I don't have this book, but in reading this, it's saying, like, just the intro is the dominance of legislatures and statutory law has put an impossible burden on the courts. Guido Calabresi thinks it's time for the country seriously to consider returning to a traditional American judicial legislative balance in which courts would enlarge the common law and would also decide when a rule of law has seen its day and should be revised. So it sounds like this guy's making the argument. There's like an argumentative essay to go back to common law, not an argument that common law is like currently what is relied upon to make any of these statutes or to be enforced in the United States.
To make it acute, he's talking about a situation like Rittenhouse where you've got these two statutes that are mutually incompatible, right? And so he's saying that the proliferation of laws, of these random one-off instantiations of statutes, is creating a whole big mess. And what is the proper role of the common law, or what is the best way forward to achieve maximal ends in that situation where you've got all these statutes that, could be completely mutually incomprehensible.
So could common law as well, right? It could also be a mess.
No, I don't think so. I don't think common law.
You don't think two judges might have a different decision on how to punish somebody or whether a thing is illegal?
Well, that's not the common law. The common law is the set of rules. So, like, burglary is the breaking and entering of the dwelling house of another.
Common law is but it's not a set of hard rules. It's just a set of prior court decisions, right? It's jurisprudence, right?
Right. So if you have one bad decision where somebody goes completely anathema, they get struck down by the higher court, but that narrows the interpretation back down. And so, like, when you study for the bar exam, you study the common law rules.
For what thing?
The criminal law is not statutory. I mean, they do talk about statutory, like homicide.
Wait, so changes. If I were to take a criminal law class, I'm going to learn. Am I going to learn that common law was the foundation for what would eventually become a lot of criminal law? Or am I just going to go and have to memorize all the common law? I feel like it's probably more on criminal procedure and current, like...
It's both. So you'll learn the common law rule, and then you'll learn the model penal code and maybe a few idiosyncratic state variations.
Okay. All right, listen, I'll take it. Take what you're saying at face value. Listen, if you want to chat in the future, we can. I got to run so I don't miss my flight. But I appreciate the conversation. Thanks a lot.
Be safe. It was great talking with you. Long-time fan, first-time listener, whatever. That's a Rush Limbaugh reference. Laugh, please.
I'm familiar. The EIB network, the golden microphone, my cigar-stained fingertips. I listened to a lot of Rush Limbaugh back in the day. Yeah. All right. Well, hey, have a good one, man. I'll see you later. Thanks a lot.
Hey, be safe.
Bye. Pretty sure my interpretation of Marbury v. Madison is correct here, but I don't know. All right. I love you guys. It's been fun. I think I've got things tomorrow and the day after that I should be live for on my wonderful stream. Is there anything else I had on stream that I wanted to do today? Not this, not that. Not that, I guess not. Fuck. Okay. All right. Well, I love you guys. It's been fun. I will see you next, or in like 3 days. Or I mean, I'll be live tomorrow. Eat shit and die. Just kidding. Love you. Bye.